Phil and I welcome you today, and we're going to really focus on trusts. We've talked a lot in the practice about the importance of doing estate planning, and trust is one of those things that we get a tremendous amount of questions on from people. How do trusts work? Is a trust something that will work for my family and for my particular situation? And so we really want to go through and talk to you all about trusts, how they apply to estate plans. So we're really going to look at, first of all, some of the common myths about trust. When people think that trust may not be appropriate for them, and talk a little bit about really breaking those myths so that you have a better understanding of how trusts play into an estate plan. I'm going to talk about the benefits of trusts and a little bit about the nuts and bolts of trusts, some about the nomenclature, the important positions within a trust that someone needs to know about, and then talk specifically about revocable or revocable trusts and irrevocable or irrevocable trusts. So why don't I go ahead and start and talk a little bit about some of the common myths that we hear in terms of trusts and how they may or may not apply to you and your estate plan. One of the first things we always hear is, trusts are really for the rich and famous. Why do I need a trust? I don't have a large estate. And in some instances, that is correct. If your estate is of a certain size, or really more important, it's what consists of your estate. And when we talk about what makes up an estate, we're really talking about what you own individually or what you may own jointly with someone else. We're also looking at your retirement plans and the value of those plans, and life insurance policies that you may have, as well as other investments. And so oftentimes, if someone owns a property, or if they have investments, accounts, savings accounts, money market accounts, those types of accounts in their own names, a trust may be very beneficial, not to you, but oftentimes to your beneficiaries, and to ensure how you want your assets to be shared and divided among your beneficiaries, so that you can sometimes control how that distribution is going to happen. So we really need to talk with you about what your wishes are, what makes up your estate, what your legacy is, and how we're going to make sure that that gets followed after your passing. So oftentimes trusts can be very beneficial, even if you don't have a very large estate that you're dealing with. The next myth that we often hear is that trusts are expensive. And yes, oftentimes putting a trust together in the beginning as part of your estate plan does make your estate plan overall more expensive. But there are savings that come oftentimes with having a trust. Number one, it oftentimes makes the administration of your estate, particularly after your passing, much easier for your beneficiaries. And it oftentimes makes it so they receive the benefit from your estate much quicker and with much less complication. So yes, they can cost a little bit more upfront, but oftentimes we see a savings in both time and administrative cost on the other end.
Particularly on, Kathy, just to jump in, particularly on probate, just as a rule of thumb, just if you look at a taxable estate, probate cost typically runs 3 to 5% of the entire estate. So if your estate is, let's say, $1 million, just for example, it's not unheard of or fairly common to have legal costs, filing costs, things of that nature. It's administration costs, $30,000 to $50,000. So it's a real advantage, particularly on the back end, if you can avoid probate.
Right. And probate is, we won't get too much into probate today, but I can tell you, and Phil certainly can tell you, that probate is definitely a process, and one that, particularly in the current environment, we have seen a tremendous amount of issues with, in particular delays, because probate requires court involvement, and the courts have really been overrun and overtaxed during this particular COVID environment, and we're finding a real delay in the processing of probate estates. Is that right, Phil?
Yeah, most of the probate courts are working at 50% capacity. So and they've also been closed down. So you can imagine the backlog, where some appointments would take a couple weeks are taking months. So the delay is just really, for a family that needs the assets, needs the money, it's really become quite an issue. One other thing I should mention about probate while we're talking about it, in Massachusetts, by statute, an estate has to be kept open for a year to allow creditors to make any claims. So that would potentially delay any of your loved ones or beneficiaries or devisees from getting needed access to family resources.
Where a trust, when we look at trusts, one of the real benefits, and Phil will talk a little bit more about this later in the presentation, but one of the real big benefits of trusts is the fact that access to the assets can be almost, instantaneous after someone has passed away, because a successor trustee is appointed who can then access those assets and be able to make distributions, pay bills, etc., without delay, without having to have court authority. So yes, it really does help to take care of the beneficiaries in a way that a probate estate or just a will does not. Another big myth that we hear is that you'll lose control of your assets. So particularly with a revocable trust, and again, Phil's going to talk much more about revocable trusts, one of the big benefits of them is that you don't lose control of your assets. That type of trust actually allows you to maintain full control as long as you're competent to do so. And if you lose your competency, the trust allows you to appoint someone as a successor to ensure that who you want to be managing things in your place has been named. And so with a revocable trust, you do not lose control of the assets. I'm going to talk about irrevocable trusts as well. Those types of trusts, you do often lose control over the assets, and I'll explain more why that has to happen, because one of the biggest benefits of an irrevocable trust is asset protection. And if you're looking to protect an asset from your future costs like healthcare, or from creditors, from lawsuits, those kinds of things, then you unfortunately, as part of protecting the asset, do have to lose some control over the asset. But I can explain a little bit more of that later on. Another big question that we get is, do I have to file a separate tax return when I have a trust? Isn't that going to cause tax complications for me and make it more difficult? Again, with a revocable trust, because you are the one who controls that trust, you are the one who benefits from it, there is no change in your tax reporting. And so even though you've set up a trust situation, you don't need to change how your assets are reported for tax purposes. Again, when we're talking about irrevocable trust situations, the tax reporting is different, and you may, in most circumstances, have to file a separate tax return for the trust. But oftentimes we can write the trust in such a way that the tax liability flows to you individually, and so you're not being taxed at a trust rate. So those are some of the things that we look at when we're doing irrevocable trusts and considering the tax ramifications for you. And the last myth that we often hear is that a trust will keep the creditors away. I want to put my assets in trust in order to protect them. Well, as we're going to talk about as we go through this presentation, because there are different types of trusts, that will depend on the type of trust that you put together. Revocable trusts, the ones that you keep control over, will not protect your assets from creditors. Irrevocable trusts will. And another thing we'll talk a little bit about is how the revocable trusts can help you to keep future creditors of your beneficiaries away, depending on how you create or how we draft that trust to meet your needs. So we can do things within a trust, like if you're worried about a child's spouse, you're worried that your son's marriage is not a strong one and may not last, and you want to ensure that that potential future ex-daughter-in-law doesn't end up with some of the assets, we can craft a trust in a way to protect those assets from any potential divorce of a child or creditors of a child.
Yeah, in case your child has a spending issue or has large debts, you may want to put it in trust to protect it from the creditors, but also maybe from your son or child. So it's something to think about. It gives you some options.
Right. Some of the times we see where people will come in and have a worry about one of their adult children's ability to be able to manage what might be a large inheritance to them. And one of the things that we can do within a trust is ensure that there's language to keep that child's share under a trust situation so that they don't end up spending it all at once, blowing, as they say, that dime that's sitting in their pocket and burning a hole. And so there are ways that we can use trusts to help to manage that situation. So now I want to just kind of give an overview or a discussion really about the benefits of trusts in general. And a few things to think about. First of all, one of the things about a trust is peace of mind. As with any estate planning, and we talk to clients all the time about this, one of the real goals of putting together an estate plan is to give yourself and your family peace of mind. It allows you to make sure that your wishes are known and followed, and that the people who you want to be involved in terms of, the trusted positions of a trustee or a power of attorney or a healthcare decision maker for you are clearly defined. So peace of mind is really something that you give both yourself and your loved ones, who now know that you have a plan that's clearly laid out and one that they can follow, whether you become incompetent or upon your death. Peace of mind is really, really important.
Yeah, I would just say in the family privacy, I kind of roll that into avoidance of probate. Probate is a very public process. Everything's filed. You can go in and look at your neighbor's probate, or you see who's getting what. I've actually had situations where nosy neighbors have come in and wanted to see what their neighbor received in terms of an inheritance. Also, we've talked about this before, but if your son or daughter is going through a divorce, they would want to know what they're getting, so that could be taken away. But a trust is private. Only the people who are named in the trust really are the ones who will receive information about it. Everyone else is excluded, have really no right. So family privacy, the avoidance of probate are really key benefits to a trust.
Right. And we talk about benefits during your lifetime. So we talk a lot about, the fact that a trust talks about what to do with your assets after you pass away. But another thing a trust does is it talks about how those assets should be managed during your lifetime, and particularly in the instance in which you may not be able to manage the assets yourself. You become incompetent, or you become incapacitated for some reason, an illness, or some kind of a disease process makes it so that you're really not able to manage your own finances. The trust can actually help to lay out how you want those assets to be controlled, who you want to control them, even while you're still alive, to make sure that those trust assets in the revocable trust situation are still there for your benefit and for your use, even if you can't directly control them. So
another way to look at it is that a last will and testament It only becomes operative upon your passing.
Right.
A trust could be used during your lifetime, particularly like a revocable trust, and you can put conditions in there and how you want the money to be used. For example, if you want a child to have a certain chunk, maybe the money can be withdrawn for health, education, and maintenance. Maybe for those specific reasons, and not give the money to them all at once. For example, in a will, if they got all the money at age 20 through a will, we call it the Harley money. They go out and buy a Harley Davidson. Whereas a trust, we can manage it. We can release certain tranches during certain periods of life or for very important reasons. Also, a gatekeeper is put over, known as a trustee, to manage the money, to make sure it's for useful purposes that the person who creates the trust wants that person to use the money for.
Absolutely. Absolutely. And the last thing here really that we have talked about is that it does make the administration of your estate after your passing easier on your loved ones. Again, it avoids that whole probate situation. It makes it so that the successor trustee immediately has access to the assets and can do things like pay bills and make distributions where appropriate. And it really clarifies what your wishes are without having to have it go through any kind of a court proceeding to make sure that they're properly followed. So trusts really do have lots of benefits, not only after you pass away, but during your lifetime as well. So I want to just talk real quickly, just some of the nuts and bolts of trusts, because oftentimes the nomenclature, the terminology that we use in trusts can be very confusing. So two of the things that I don't have on here that we're going to talk specifically about are the revocable or revocable trusts and the irrevocable. And one thing to remember about a revocable trust is it is a trust that you continue to control and have the ability to change its terms during your lifetime. Where an irrevocable trust situation is one in which once you create that trust, you have really put it down. It is now written in stone and cannot be changed.
Yeah, I look at it, irrevocable trust is really a steel box. You put the asset in the steel box, so protect it against creditors. But along with that benefit, you lose control. So not only is it protected from creditors, but also protects it from you. So things to consider. I know Kathy's going to talk about irrevocable trust in a moment, but just use that imagery as you think about the difference. Revocable is changeable, during the grantor's lifetime.
Things that you can change. And as Phil just used that word grantor, within a trust, the grantor, trustor, settler, and we use these terms oftentimes interchangeably, but that's the person who's creating the trust. That's the person who has decided that they're going to put this trust together for whatever purpose they decide to do so. And that we can either use grantor, trustor, or settler. That's how you'll hear them referred to usually. The trustee is the person who is responsible for administering the trust. Now, sometimes, like in a revocable trust situation, the grantor can be the same as the trustee, and they often are. So the person who created the trust is oftentimes also the same person who controls the trust, is responsible for its administration. And then another term we hear is a successor trustee. And that would be the individual who you have named, individual, or sometimes you actually are using a trustee company. Some banks, some financial institutions will act in that capacity. But the trustee or successor trustee is the person who steps forward when the original trustee is no longer able to act, whether they've passed away or whether they've chosen to resign for one reason or another. One thing to know about the trustee is the trustee always has what's known as a fiduciary responsibility to the trust and the beneficiaries, which means that the trustee is charged with having to act appropriately on behalf of the trust and on the beneficiaries, and to be following the terms of the trust and to be doing things like making appropriate investment decisions on behalf of the trust and the beneficiaries. So
Excuse
that,
me, Kathleen,
excuse me.
I'm going to interrupt you. I have a question.
Sure.
For a trustee to pay bills from a trust, how
Mhm.
exactly is that done? Is there a checking account established in the name of the trust so he or she can write checks and pay bills, or do we need to set up a checking account in the beginning in the name of the trust?
Yes. And so, in order to act on behalf of the trust does need to have two things happen. Number one, it needs to be properly funded, which means that assets actually have to be transferred into the ownership of the trust.
Retitled into the ownership. If a bank account is in your name, Philip Summers, if you put it in trust, now we got to put it in the name of the trust. So it's the trust actually now owns the asset.
Correct, correct. And the trustee must be recognized by the financial institution as the person who is able to act on behalf of the trust. So it does differ by financial institution, but for the most part, they usually want to see either a copy of the trust so that they can see that the individual has been appointed as the trustee. And we put together what's called a trustee certificate. This is a document that actually outlines the important terms of the trust, when the trust was established, who established it, what the name of the trust is, and the date that it was created, and who the trustee is. And then the financial institution can rely on those documents to set up the appropriate accounts, including a checking account if the person or the trustee is going to be writing bills, in order to be able to transact on behalf of the trust.
And then the next item is assets. There's a misconception that only financial assets, bank accounts, maybe a Fidelity account can be put in the trust. That's true, but you can put a whole lot more in a trust. If you have valuable artwork or personal items that you want to make sure go to a certain person. They're even what's known as gun trusts. So guns have some guns have a considerable value. They can be put into a trust, and the trust owns the gun. So it makes ease of transferring it to the beneficiaries. So there's many different types of assets you can put into a trust, including your home. You can put it into a trust. So don't think it's just about putting financial accounts in. It's a whole lot more you can put in there.
Right. The other thing, though, that we often see is that clients will come into the office and maybe they've had a trust created with another law firm. Wonderful trust. It does everything that they want it to do, but they've never actually funded the trust. And funding the trust is when we move assets into the trust. Now, if you don't fund, particularly your revocable trust during your lifetime, then you have not used the trust to its fullest value. And what I mean by that is that when you die, if your assets are still owned by you and not in your trust, then we have to go through that whole probate process, usually to get the assets into the trust. And so to make that part of your plan really work well, that is the avoidance of probate, we want to move the assets into your trust while you're alive. So moving your property, moving your appropriate bank accounts, signing over your personal stuff to your trust is part of the process of making sure that it's properly funded and that those assets.
You can also move assets out of a trust, even though you put them in assets in a trust, retitle them. As the grantor, you still have full control. When I'm talking about revocable trust now, you still have full authority to, suppose you want to gift something out of it to a loved one. You still have that ability to do that.
Right, absolutely. And then one of the other terms in trusts are the beneficiaries. And this is where in the trust we identify who you want to receive assets from your trust, either during your life or after your passing, who you want to benefit from the trust, how you want them to benefit, if you want them to receive the assets outright, or if you want to continue to have the assets held in trust. Phil had used the example of minor children. You know, you have a child who is 21, 25, even 30, and you believe that they really still can't manage the assets outright if they were to get them. You could keep them in ongoing trust and have the trust continue to handle those assets and manage them for their benefit. You can also provide for organizations, charities, and so lots of different ways of identifying who your beneficiaries are and providing the instructions as to how you want those beneficiaries to be taken care of. So those are really the common terms that we see in a trust and the important roles that they play within the trust. So now I want to really move forward on talking about trusts, and we're going to talk specifically about the revocable and irrevocable trusts, but I also wanted to give everybody a little bit of a flavor that there are many different types of trusts. I mean, I always say to clients when I'm talking that there are, a million types of trusts out there, but trusts tend to fall into specific categories. Revocable trusts are one. Again, remember, those are the ones that you retain control and benefit of. Irrevocable trusts, as Phil described, they're like the steel box with the purpose of trying to protect assets. But we also have some specialized trusts. If you have a child, a loved one who has a special need, then utilizing what we call a special needs trust can be very beneficial. And there are two types of those trusts. There's what we call a third party trust. That's one that's often created by someone else for the benefit of another who has special needs. And there are rules around how that trust can be created and funded in order to make sure that when the special needs beneficiary passes away, there isn't a need to pay money back to someone like the state, the Medicaid program, or the federal government for benefits that that person may have received. Self-settled special needs trusts are very different. This is when the special needs person themselves or a loved one on their behalf creates a trust and funds it with the special needs individual's assets. Their own money goes into that trust for the purposes of keeping them on some kind of benefit program. In that type of trust, we actually have to pay the state back with any monies that remain in the trust when the special needs person passes away. And Carol, I think there was a question that came up, correct?
Yes, there's actually a couple. One is, can you have more than one trustee?
I love that question. So can you? Yes, you can.
Absolutely.
Do we advise it?
Do you want to?
We don't. And here's why. Certainly there are situations in which having multiple trustees can make sense. Let's say you've got, you are the trustee of your own trust, you are older now, and you want to name another loved one like a child to be able to be a co-trustee with you to help you write your bills and manage your finances. And you want that now, even though you're completely competent and capable, you just want the assistance. But we have to think about certain things when we have co-trustees. Number one, remember, financial institutions get a little concerned when they deal with co-trustees because they don't know, can these people act alone? And that's one of the things you have to think about when you put the trust together. Does every decision they make have to be together? Do they have to sign every check together? Those kinds of things can get very complicated. What happens if they don't agree? How does that get resolved? And so we really strongly recommend that you name one individual at a time. Now, you certainly could name one successor trustee and then have someone to serve after them and someone even after them if you chose, so that you always have that position covered. But recommend that you consider not naming co-trustees. It gets very complicated.
One situation we see and we would advise against, we have clients that come in and say, well, our two children, they don't really get along. So, I think we'll make them co-trustees. So hopefully they will learn to work together, and this could be a bridge. And that rarely works, and oftentimes that becomes a greater source of friction. So I would just caution you to be careful, really think about through who you want to have, and also the successor trustee. So think those things through. This is not an instrument to as a social engineering to get families together. It's really to make sure your wishes are carried out and who's going to carry them out the best.
And then there's another question. GRAT trust may be a good idea as well. Can you explain a bit?
It's known as a grantor retained annuity trust.
Thank you.
That's what a GRAT stands for. Oftentimes for large, it's to minimize taxes is certainly one of the advantages. Also, if you're going to make large financial gifts to family members, it's a mechanism to do that.
Right, but they are a specialized trust, and if it's something that you're interested in, certainly happy to help you kind of explore that a little bit better to see if it would be of benefit for you. So again, some specialized trusts that we talked about are the special needs types of trusts. Charitable trusts, these are specific trusts that are set up for not only tax purposes or not only to take care of charitable organizations or charitable wishes that you may have, but they can have great tax benefits as well to you, both currently as well as to potentially your estate after your passing. And then Phil had alluded to one type of specialty trust, the gun trust. Guns are interesting. There are laws around how they get passed from one owner to another. For instance, people need to be, properly licensed to carry a gun. And if you own firearms and are looking to pass those on and passing them on to someone who may not be properly licensed, they can't carry those. They can't transport them from one place to the other. And gun trusts will deal with how that ownership can get properly passed. Pet trusts are another type of trust that we see as a specialty trust. People own pets and want to make sure that their pets are properly taken care of after their passing. You can't leave money directly to a pet here in Massachusetts, unlike Leona Helmsley, who in New York famously left millions of dollars to her dogs. But in Massachusetts, we can create a type of trust that will ensure that there is money to continue to provide for pets that you may have and to pay caregivers who may be providing care for them, as well as like vet bills, etc., as a way of making sure that the pets are properly cared for. And there can be, as you all know, pets that live for a long time, turtles, parrots, horses, that all need special kind of attention in terms of your estate plan. And the last type of specialty trust we have written here are life insurance. Life insurance is one of those things that the value of the life insurance policy, the proceeds that are paid out at the time of your death, are usually part of your estate when we are trying to determine an estate tax liability. And life insurance trusts can be used as a way to help to segregate the value of life insurance policies out of your estate so that they are not part of the estate tax calculation. So I'm going to pass it over to Phil, and Phil, have you really focus on the revocable trusts.
Sure, thank you. So we talked a little bit about revocable trusts. Remember, the key advantage of it can be revocable. It can be revoked during the grantor's lifetime. We learned about who a grantor is previously as a person who sets it up. So this gives you maximum control and ease of administration going forward. Now, when you pass, the revocable trust now becomes irrevocable. And so the terms are followed in terms of distribution, how the assets will be continued to be managed with the successor trustee. One of the advantages, certainly is around estate planning, but also it can be used as a tax tool to catch up certain portion of the estate tax in Massachusetts. We are known as a threshold state. So we're $1 million. If you are $1 over a million, the full 1 million is taxed. So revocable trust can be used, a certain type to catch up the estate tax, particularly with couples. You can catch up the estate tax up to the maximum allowed. So it would bring down the full taxable estate when the second to dies. It's really an advantage for the beneficiaries down the road. But just think about as a mechanism to, hopefully save on estate taxes.
Right. It helps
We talked about revocable trusts. They're easily to amend. We can change it. There's no delay in getting the funds. They're immediately available to loved ones. It's not delayed in a probate court, which can take a year before final distributions. And also it's very private. Only the people who are named in it are legally entitled to any information on the trust. So control, just think control with a revocable trust. Don't think of security and protection. That's not a revocable trust, but maximum control for the grantor and also certainly for the beneficiaries.
And one of the other things too on revocable trust to remember is that, again, not only can you control how assets are distributed during your lifetime, but upon your passing, if you choose to make sure that those assets continue to be controlled for your descendants, for your beneficiaries. For instance, the trust could say, I'm leaving my assets directly, let's say, to my children. I'm going to go ahead and distribute them to them equally. That's one of the ways that the trust could determine how beneficiaries will receive their inheritance. But you also could decide to, let's say, leave that inheritance to someone in stages. We had mentioned before, when you have children who are, or even adult children who are under a certain age, you may not want them to receive the inheritance all at once. And so you could do something like, let's give them half or a third of what might be in there when they hit the age of 25. We'll give them another half when they're 30, and we'll give them the rest of it when they're 35. Now, during that time period, before they reach the age of 35, the trustee will be responsible for managing the assets and can make distributions to the child above and beyond what it is that you're giving them at those certain ages. And so it really is a way of making sure that monies are controlled in terms of their distribution to your beneficiaries, and that someone is overseeing the funds and overseeing how they're being used with respect to the trust. Another thing that you can do is lifetime control. We talked a little bit about when you have a beneficiary, a child, let's say, who's in a marriage that you're concerned about, and you want to make sure that the assets do not end up passing to the potential ex-spouse. You can continue to have lifetime control of those assets within the trust. Now, that does mean that your child or your beneficiary will not get the assets directly themselves. They will be retained within the trust and continue to be controlled by the trustee. But you can decide how you want that trustee to distribute the assets. For instance, they can give it at ages like we talked about. You can leave it so that the trustee has full control and only makes distributions when they believe it's appropriate to do so. Or you can do a combination. Let's say you decide, I want to make sure that my child gets a certain amount of money each year, maybe a percentage of what is in trust for them, 5%, 10% of what the principal value is. And I want to leave the rest of it under the trustee's control to distribute as they believe appropriate. So lots of different options on how those distributions are made to the beneficiaries.
And just as a quick example, we had one client that created a revocable trust, and they're supposed to get half the money at age 25, another half at age 27. But when the child reached age 25, the grantor did not believe their child was sufficiently mature to handle the money. So they changed it. It's revocable. So they changed it. So they pushed it out to 27. When the child at 27, they kept pushing it out. So, that's the beauty. They can change it depending on the situation.
Right. That's really the benefit of revocable trust. If you are competent to be able to make those changes, then you can make those changes to continue to reflect your life, your values, and what's happening with your potential beneficiaries and how you want to see things managed. One of the things too we talked about before is that revocable trusts really can incorporate your own personal values and desires, making sure that charitable organizations that you want to have supported are supported through your trust, addressing things like the care of your pets, making sure that the things that are important to you during your lifetime are reflected within the terms of the trust, and that the distribution to your beneficiaries is done in the way you want it to be done. So one of the big things, though, about revocable trusts to remember is that they have tremendous benefits except for one, which is that they don't provide any protection of your assets from your creditors, including things like long-term care costs. If you needed something like nursing home facility care in the future, the value in your revocable trust is considered to be yours. It's considered to be available to you, and thus there's no protection, even though it's in a trust format.
And Kathy, just for what would long-term care cost per month?
So right now we're seeing them anywhere between about $13,000 and $17,000 a month. And
so that will rip through most people's hard-earned life savings if they had to pay for it privately.
Very quickly, very quickly. So let me go ahead and move forward with talking about irrevocable trusts and how those work. So as Phil said, irrevocable trusts we like to think about as steel boxes. The whole point of an irrevocable trust is to put an asset or assets into it and protect them from your ongoing needs or your future needs. We want to make sure that they're protected from your creditors and protected from your long-term care costs in the future. So for example, you own a home down on the Cape, the second home, family loves it. You want to make sure that that value, that home, continues to pass on to the next generation. So you set up an irrevocable trust and you place that home into the irrevocable trust. Now, let's say you have 3 children and you want your 3 children to be the beneficiaries of that trust. So we write the trust to make sure that the 3 children are named as the beneficiaries, and after your death, the 3 children will get the value of the trust outright, and then they can do with that value anything that they choose. When you set up an irrevocable trust, you want to think about a couple of things. Number one, once you draft the trust and you create the trust, remember we said you can't change its terms. I'm going to explain a little bit that, we always keep a little bit of a back door on an irrevocable trust, but it's not easy. And you certainly can't decide that you've changed your mind with this example of the house down on the Cape, and you now want it back again. Once you put the house into the irrevocable trust, you cannot decide that you want to change it and have it come back to you, so you now own it. Another thing to remember is that once you put the asset into the irrevocable trust, you no longer can benefit from that asset. So what I mean is that you can't say, hey, I've changed my mind, sell that house and let me have the value to do with it whatever I want. That is now gone. You are no longer the one who controls that asset, and you can't make the decision to use that asset for your use again in the future. So you can't be the trustee of this type of trust. You cannot control it. Again, I'm going to talk a little bit about the back door that we put in to be able to get access for you if necessary. Another thing about irrevocable trusts is that when we use them for the purposes of protecting the asset from your long-term care costs, there is a 5-year look back. And what that means is that you must set up the trust and fund the trust at least 5 years before you would ever need to ask the state to help to pay for something like long-term care, to apply for Medicaid or what we call mass health. So this type of planning has to be put in place at least 5 years before you need the benefit. So let me just kind of walk through how an irrevocable trust really works. So you take that house down in the Cape and you put it in the trust and you make your 3 children the beneficiaries of the trust. So after your passing, they're going to receive that property. We name one of them as the trustee. So we can do that. We'll name one of your children as the trustee and they'll manage the asset. Now we can put some safeguards in place. For instance, you like to use the house down on the Cape and you don't want your children being able to say, well, mom and dad, we've decided you no longer can come down to the Cape, or for them to go ahead and sell the house without your agreeing to it. So there are some safeguards that we can put in place to make sure that you continue to be able to use the property in terms of going down to it and physically using the property. And we can put some safeguards in to make sure that the trustee cannot sell that property unless you agree. But remember, if there is a decision to sell the property, you don't get the value of that property back again. It stays in the trust. Another thing that we can do is that there's that 5-year look back that I talked about. So let's say you set up an irrevocable trust today with the intention that you're going to do fine and not need any kind of state assistance for the next 5 years at least. You're hoping 10 or 15. But something catastrophic happens in year number 3. And now we have a problem because you either have to find a way to private pay for your care for at least the next 2 years to get us through that 5 years, or we have to find a way to break this trust. How do we provide for you? If you don't have money outside of the trust to try to make sure that you can get through the 5-year, and we have to somehow get you money from the trust, remember, we can't give it to you from the trust directly. You can't be a beneficiary of that trust. You can't control it as the trustee, and you can't be a beneficiary. Because if you are, then the state would say, go spend all that money first and then come and see us. So we put a little safety valve on the trust. And what that safety valve says is that the trustee, who is one of your children, can make the decision to go ahead and give monies, if there is value in the trust, to the children, so to the named beneficiaries. And then if out of the goodness of their hearts, they're willing to give that money back to you, that's how we can funnel money out of an irrevocable trust for your benefit. We can't give it to you directly, but we can have it pay to your beneficiaries, and if they're willing, they'll give it back to you. Carol, I see there's a question.
Yes. So someone asked, and I'm not sure if you answered this, can the trustee sell the home for the use of the former owner? I'm not sure.
Well, the trustee would always have control to decide to sell the property unless we kept that little agreement that they had to get you to agree to that as well. But let's say you had a second home in that trust and you all decided it was appropriate to sell that house. The trustee then could sell the house, but the money, the value that came in from that sale would stay in the trust. And if it's an irrevocable trust, you can't get the benefit directly. We have to take the money, give it to the beneficiaries, and then hope that they will give it back to you.
Or Kathy, the house, those proceeds could be used to buy a different house if that's appropriate. But it'd be the trustee's decision. It would not be, unfortunately, the grantor's decision on that.
Unless we kept it so that they had the right to kind of veto a sale. So as Phil was describing, the other possibility is that the trustees could sell the current house and the trustees could buy a new house. And the value of that house and the ownership of that house would stay in the trust. Does that answer the question?
I think so. I've got a couple more here. Jay is asking, using your example of the children receiving the money, are they triggering a tax event?
So there are certain tax issues that we have to be aware of, but as beneficiaries of the trust, the value that they take from the trust is not taxable to them. It may be taxable at the trust level. So for instance, let's say instead of a house, we had investments in the trust, and those trusts, those investments were in securities, stock, that kind of thing. The sale of the stock to create the money may cause a taxable event for the trust, and the trust will have to file its own tax returns each year. So
That's for an irrevocable trust, not revocable.
Irrevocable trust.
Revocable goes under the grantor's Social Security number. Irrevocable has its own tax ID.
Exactly. So the irrevocable trust will have to file its own tax return, and it may have a tax liability. But the distribution to the beneficiaries, it goes to the beneficiary tax-free. Now, once it's in the beneficiary's hands, and of course they go and invest that money, it's now subject to their tax rate and part of their taxable estate. But the distribution itself is tax-free.
Okay. There's more questions.
Go ahead.
Would the money be seen as income to the beneficiary, even if they are just passing it for tax purposes?
No, again, the beneficiary would receive it tax-free, but there may be gift tax problems for the beneficiary who is giving it back to their parents. So let me explain that. Each of us by law is allowed to give $15,000 per person per year under the current tax law. So if you are taking $15,000 out of the trust and giving that back to your parents, there's no issue. Let's say your parents need $50,000 out of the trust, and you're the only beneficiary. You take the $50,000 out and you gift that to your parents. You're allowed to give them each $15,000 or $30,000, but you've given them $20,000 more. So what you have to do, you're supposed to file a gift tax return in which you report to the IRS that you have given $20,000 more than you were supposed to. And the IRS will file that away under your Social Security number. Now, there's no tax due at this point, but that value, that $20,000 value, is kept in your IRS file. And under current law, when you die, they add up the value of your estate and they go back and add all of those gift returns that you have filed. And if it's over, and I believe the number right now is $11.4 million, then you have a federal gift tax issue. It's not an issue that most of us have to deal with. But that $11.4 million level is subject to change. And who knows what's going to happen come the new administration in terms of potential changes to the gift tax allowance.
All right. I think Barbara just asked a question, but I think that just answered it. But there is another one. Would it be best to gift the house back to be used as income to keep your loved one home, or a reverse mortgage?
So I'm not really sure what that is about, and whoever asked that one, I mean, so one thing to know is that if you're using an irrevocable trust and you place a home into an irrevocable trust, you're not able to get a reverse mortgage on that, because remember, the value of the home is in the steel box and it's not for your use and benefit. So you couldn't then go get a reverse mortgage on it, or even a traditional mortgage, in order to be able to use its value for your benefit. There are restrictions on all of that.
And this is also a good opportunity where you want to pull in your financial planner to help make the decisions as to what asset you tap, which assets you really can't tap. So, but these are great questions. Reverse mortgage is a whole separate area. There's pluses and minuses. And again, these are great questions for a financial planner.
Right, right. And this is part of what we look at when we're deciding what is an appropriate asset to put into an irrevocable trust.
All right, you are free to move on, Kathleen.
Wonderful. I did have a quick mention in here about the life insurance trust, and I talked about that a little bit. It's considered an irrevocable trust once you set it up. And again, its purpose is very specialized, and it's for the purposes of removing the value of that life insurance policy from your taxable estate.
It'd be a nice legacy to give to your children. So if you have 3 children, you can set up 3 separate policies. So it's a nice way to take it out of your taxable estate and have it protected for them.
Right, right. We talked about the special needs trusts. I talked about the difference between those third-party special needs trusts and the self-settled special needs trust. And it's really about how monies have to be spent or excuse me, have to be paid back to the state and under what circumstances. With a third-party special needs trust, when it's funded with someone's money other than the special needs person themselves, there is no payback provision. But when it is settled with the individual's monies, then there is a payback provision. And it's really important if you have someone who has special needs as part of your family unit, that you really are careful about which trust you are utilizing and how you're funding that trust so that you protect money where you can. And one of the really important things we want everyone to remember is that trusts are part of an overall comprehensive estate plan. So trusts are used still with wills. Even though we have a trust, we always have a will as a safety net, just in case we've forgotten somehow to fully fund those trusts. And the documents that control things while you're still alive, but if you lose your competency or capacity, are still critical. Your healthcare proxies, your powers of attorney, living wills, your HIPAA releases, and those personal property memorandum, if you have specific things that you want to give to specific people, are critical to make sure you have part of your comprehensive overall estate plan.
It's also important to occasionally look at it, particularly if there's some changes in your life, a passing of a spouse, changes in your financial assets, if you come to some money, receive an inheritance. And also when there's changes in the laws. We went through a major change in the probate laws about 5-6 years ago. Critical points where you want to take a look at your plan to make sure it's still relevant, it's up to date. And also if your values have changed, if you want to carve out maybe for charity or for you want to help one child over another, these are reflected in your plan, and it's a living plan. It changes over time.
Absolutely. And I think Phil, you did mention health, but that's a critical point when if there is a change in your health or your loved one's health or a child or beneficiary's health, we really want to take a look at your plan and see how that impacts your overall plan and your decision making.
Well, Kathy, we do have a question from, it looks like Judy maybe. Do you have to have all your assets in a trust to avoid probate? Is that what fully funded means? Well, yes and no. First of all, when you funding means you change the title of the asset. So if you have a bank account, it's in the name of Philip Summers. You put it into the trust, you change it to the name of the trust. So now that means you're funding the trust with the asset. There's other techniques to avoid probate. One of the easiest ones is to have jointly held accounts. So if you have a bank account and it's in you and your spouse's name, upon your passing and by operational law, it goes right to the surviving spouse. Same thing with if you own your house together with your spouse. Upon your passing, it goes again automatically to the surviving person. So, so jointly held accounts avoid probate, trusts avoid probate. It's really the assets that are in the decedent's name solely.
Another way of avoiding probate is with named beneficiaries, retirement plans. So a retirement plan, 401k, 403bs, IRAs, they do not go into a trust in terms of ownership. they have named beneficiaries. Usually those named beneficiaries are individuals, whether it be a spouse, whether it be children. Sometimes, though, the trust should be named as the beneficiary, and that's something that we really need to look at individually and with your financial planner to make sure that the assets, when they have named beneficiaries, are properly designated. Well, we really want to thank everyone for
Yes.
joining. I hope this was helpful. And if there are additional questions or concerns that you have, feel free to reach out to us. We'd be happy to answer them for
Yes.
you.
And have a wonderful holiday season. And we're looking forward to getting 2020 behind us and on to 2021. Hopefully a better year for everyone.